I'm Shawna Brown, and I'm counsel here at the Elder Law Department at Mandelbaum Barrett. In our practice, we often get calls from people who have just lost a loved one and are very concerned about what's going to happen next in the estate. Sometimes they say, there's a will, but this is not what my loved one wanted. Or, whoever was put in charge as the executor under the will is not the person that should be handling the estate. They're a spendthrift or they have some issue that they're not going to do a good job. People are not powerless in these situations, and there are things that can be done to try and prevent a will from being admitted to probate in that situation. This is by using something called a caveat. So a caveat is really a formal objection or a warning that's filed with the surrogate's court in the county where the person who died lived, and it operates to, at least for a period of time, prevent the probate of the will or the appointment of an executor. Kind of puts the brakes on the probate process. Like I said, a caveat is commonly used when someone thinks the will is invalid for some reason. So maybe you think your loved one didn't have the right mental capacity to execute a will. Maybe you feel they were unduly influenced by somebody. So by filing that caveat, you will prevent probate of the will for the time being. So likewise, as I said before, if there's a dispute or an issue over who should be managing the estate, you can also file that caveat to prevent them from being appointed. So who can file a caveat? It can really be any interested party. Most commonly, this is someone who's an heir of the estate or a beneficiary of the estate, or somebody who would have a financial interest if the will was invalid or if that person had died without a will. So what happens is once the caveat is filed, the court will not proceed with probate and the appointment of an executor. The court will require that a complaint be filed with the superior court and that be resolved before probate is done. So for example, if you file a caveat, even if the person later tries to probate the will, the court's going to say, no, we have this caveat on file, so you can't do that right now. You have to go file a complaint to get the will admitted to probate. So the caveat, it needs to be filed fairly quickly. In New Jersey, you cannot probate a will within the 10 days after someone dies. But if you want to prevent it happening, after that 11th day comes, you need to file the caveat as soon as possible. You can file it later than that, but there's always the possibility that probate has already happened. Once that caveat is filed, the surrogate cannot act on the estate. So like I said, something would have to be filed with the superior court and a formal legal action has to be instituted. Now, obviously, if that action is instituted and the court finds that the will is valid and that person should be appointed as executor, that may happen. But this at least gives you an opportunity to put the brakes on the process so that the court can examine it more closely. Another important thing to consider with a caveat is that some wills have a clause that's known as a interim clause, or more commonly a no contest clause. That's something that a testator will put in a will to prevent people from challenging it. So, the clause will usually say if someone challenges my will, they'll lose their gift under the will. So you have to think about this carefully. If you file a caveat, that could be considered, contesting the will because you're preventing it from being admitted to probate. Now, if you have good cause for doing that, then the court may find that and, you may end up getting your gift. An example of that would be, if somebody, it's found that somebody told them to sign the will and leave everything to them, the court might say, yeah, you had good cause to block the probate of this will. But, if you're just mad that you're not getting something, you don't really have good cause, the court may find that, that no contest clause is enforceable and you won't receive your bequest. So if anyone needs help with preparing or filing a caveat in New Jersey, that's something that our firm does all the time, and we're happy to help and talk through the pros and cons of doing that. And, also if you're in a position where you're trying to probate something and a caveat has been filed, with dealing with that as well.